The U.S. Supreme Court is playing it close on the birthright citizenship question, a very important question that affects thousands and thousands of children into the future.
Yeah.
Into the future. I sat and heard the entire 2-hour argument before at the Supreme Court, and we're here to discuss.
Hey, I sat and listened to it too.
As well.
Yeah.
We're here to discuss what we got out of it. I'm Sam Shihab with the law firm of Shihab, Burke.
Brian Burke from Shihab Burke. It's Monday, it's 6 p.m., which means we're here talking about an immigration issue that may interest you.
So this is really important because part of the executive order will not issue a citizenship to children born to immigrants, non-immigrant visa holders,
Yep.
and those who are undocumented.
Yep.
And the effective date was in February, and then 30-day study, and then an implementation. The court said, the government said the 30-day implementation hasn't started yet, so if they prevail, there will be a 30-day period, and then they will implement. But surprise at the Supreme Court, because the plaintiff, which is the government, had a very smart maneuver and did not bring the birthright citizenship question directly before the court.
It's a question of, is it lawful? Can the executive branch, can the president change the rule and say, birthright citizenship doesn't just mean being born in the United States anymore? And that's not what came to the Supreme Court. What came to the Supreme Court was the question of, can a lower court, can like a federal district court, issue a nationwide injunction that prevents the executive branch from, executing its constitutional duties to enforce the laws and execute the laws as it sees fit? It's basically, it wasn't about the substance of can the executive do this? It's can the courts stop the executive from do this while the courts talk about whether or not what the executive doing is legal.
So,
say it another way, please.
In another way, the federal government said the impact of the court decision, the lower court decision, can only apply for the plaintiffs, for the few individuals that filed the lawsuit.
That's what the government argues, yeah.
And that's what the government argued. They asked the Supreme Court to issue an order to limit the lower court decision to only those who filed the lawsuit. And those who did not file the lawsuit, the executive order should continue to deny birthright citizenship to their children.
Yeah. And that's what these arguments about. The government arguing, here's why you should only apply this to the people who actually sued the government, and the other parties being the states saying, no, this is an appropriate scenario to enforce this, not against just for the people who sued, but for everybody.
Yeah, and that's why people get frustrated with the legal system, because it's complicated, and people want to say, is my children going to get their citizenship when they're born in 5 months? My wife is pregnant. Is my child, I'm here on an H-4 visa, I'm here on an H-1B visa, I'm here on an L-2 visa, or I'm undocumented, and will my child become a citizen when they're born here in the United States, as it has been for the last 125 years?
Yep.
And what came before the court is a technical maneuver. The question on birthright did not come straight to the court. The federal government did not want to do that. They wanted to ask the court to only limit the ruling on the plaintiffs who filed the lawsuit only. That's what came before the court, which is a completely different question. We thought we are going to get
at least
a taste of what they feel about the real question, the elephant in the room.
Whether it's lawful to change what the last 125 years of policy have been on birthright citizenship. Yeah.
But here's the reality, guys. If the court agrees with the government and says that the lower court injunction should only apply to the plaintiffs in the case, then the executive order will continue for a long time before they decide the question of birthright.
Yeah.
It could be years before that question comes before the court.
I'll sort of play this out. So people, the executive is allowed to do what it wants while this court case percolates up, and it'll go through an appeals process from the lower courts and eventually up to the Supreme Court, so the Supreme Court can make a decision on this. In the meantime, for those years or months, basically the executive will be saying, nope, you're not a U.S. citizen to a bunch of children, and denying them those benefits until the Supreme Court says otherwise. And except in the state in which the lower court
has ruled in the favor of enjoining the executive order. So if somebody was born, let's say in New Jersey,
Yep.
and there is an order from the lower court in New Jersey, which is binding on New Jersey,
Yep.
right?
Yep.
Then people born in New Jersey or live in New Jersey who are born in the United States may be U.S. citizen, but once you cross to New York, if there's no ruling in New York, then they no longer are U.S. citizen, and then they go to another state, which had so it's
That's what
chaos.
this is about. So basically, the government's saying, so the Solicitor General for the U.S. government, who wants to basically get rid of this nationwide injunction, says, no, the rules of court say you only give benefits, you protect the people who actually come to you and sue. Whereas the states who basically got granted these injunctions saying, it's ridiculous. You create a patchwork scenario where a child born in Pennsylvania is a citizen, but a child born in Virginia is not a citizen. And what happens when that child moves from Virginia to Pennsylvania?
Right, not necessarily where they're born, could be where they live.
Yeah.
It doesn't matter where they're born, it matter where they live, which is because the ruling is if you're born in the United States, you're a citizen. If you're born, you're not a citizen. So it's where you live, not necessarily where you're born, or could be both. We don't know yet. Now, let's turn our attention on what did we hear the court argue during this 2-hour session, Brian?
So, the court. I'm gonna say. Well, the court doesn't argue. The parties argue, but the questions that the judges in the Supreme Court ask give you an idea as to where their brain is at. And there were a lot of questions, from people, the more liberal judges, basically questioning the liberal judges are essentially saying, well, if there's an executive that is out there, the executive branch of the government, the president, who's basically going outside the law, what should stop us from telling, if we're going to, what the government is saying, what the liberals are saying, what the government is saying, if I determine that the government's acting unlawfully towards one person, at least I'm pretty sure they are, especially I'm going to say, don't enforce this change against Dave because it's clearly unlawful. Why the heck shouldn't I enforce it against Danny and Davey and Steve and Bill and Jimmy and Jane? Why should I allow you to engage in something that I'm pretty sure is unlawful and we're going to overturn soon against everybody else except for one person? The law is the law.
And the conservative judges were saying that nationwide injunction, the way the lower court did it, and I think there are 3 courts that did that, are not good for the country because, number one, there's no history that support the power for the lower court to issue a nationwide injunction.
Only
because
since like the 1960s,
They are in their own area, their district, they cover their district, and that district only, they should issue ruling to cover their district. They cannot be binding other courts in other area.
Yeah.
There's no history, there's no constitutional basis for it. And what would happen if 2 courts issue conflicting nationwide injunctions, inconsistent with each other? How do you reconcile these? It's because it creates confusion. So the conservative judges were against the nationwide injunction, and also they were in favor of shooting it down where the liberal ones were for it, and I count 3 justices who are in favor of continuing the injunction, and I count 2 that are clearly against. So the 3 and 2 is what? 5.
Yeah.
Leaves 4 unknown.
Up in the air. Yeah. Yeah. And I would just also add on the things that the conservatives were asking the question about, well, wouldn't we be usurping the power of the executive branch? It is their job to execute the laws and execute the Constitution. And, if we are stopping them from immediately stopping them from doing what they want, aren't we overreaching? And that's sort of that. But what if it's such an obvious reach is what the other side says?
As we're running out of time, so on the question of birthright citizenship, which is the elephant in the room that was not discussed.
They were very intentionally not discussing the substance of it.
Not all of them. So a lot of them were very liberally saying it's absolutely illegal what
Yeah,
you know,
several of them are saying, you got government, either one of those, I can't remember who it was, they said, great strategic choice government, because you clearly got pounded on the issue of whether or not the executive order is lawful in the lower courts. So now you're fighting that battle, you know you're going to lose with us. Instead, you're going after the concept of an injunction. You know.
So on the question, so if the executive order nationwide injunction is shut down by the court, the executive order limiting birthright will go through, even though the court has not decided on birthright citizenship question until into the future, until we see it in the future one more time back to the court. I see the court leaning towards shutting down the nationwide injunction. That's how I see it, leaning in that direction, Brian. I see the court leaning towards preserving birthright when it comes to them in the future, and I see a dilemma the court has to reconcile these, because ultimately it's the elephant in the room. Ultimately is whether or not birthright citizenship is being protected or not.
I agree with what you have said and what the questions that the conservative justice to confirm, you know, what you're saying, where it's likely to do on the concept of the nationwide injunction. I think that in the back of, I mean, you know, we're talking about, I think the real problem they have is, well, what happens if we say no more? First of all, I don't think the Supreme Court likes the idea of totally kneecapping their ability. They'd say never can we get a nationwide injunction. I don't think they like. I agree. I don't think they like the idea of that. I think they are thinking about their
limiting.
But I mean, they're saying we don't want to encroach upon the executives, but we don't want to total executives' power. But we don't want to. Our job is to determine what the law is. We don't want to totally cut ourselves the ability, our duly constitutional authority here either.
Their decision is going to impact what's going to happen to birthright citizenship.
Yeah.
I know that they have a decision on injunction on a broader scope, right? Not only in birthright, but many other scenarios. But their decision will directly impact birthright citizenship. Sure. And the question becomes, how can they balance it? Because I think the needle is a little bit favorable on birthright, and the needle is a little bit unfavorable on nationwide injunction. So there's a couple of justices, maybe out of the four, maybe one or two are going to struggle to reconcile those two, their ultimate goal and their hate for nationwide injunction, but their ultimate goal to protect birthright citizenship.
But it's one of those, you know,
tension that
cut off your nose to save the face. Well, you know,
that's the problem.
And those who know that I'm gonna keep birthright citizenship, saying why the hell am I going to wait about this? But it can conflict of their constitutional principles. You know, what are the powers of our branch of government? Very, very interesting.
Very difficult case.
Yeah.
We always promise you guys to do it in 10 minutes, and we end up doing it in 12 minutes. So
we always, every time we have that result too. Yeah.
Yes. So we have to say in 12 minutes or less, to stay honest on this. So there were some questions that are flying. And we want to invite people to ask questions on this or anything else on YouTube. And as we ask questions, there is questions on birthright citizenship and also on our website, which is immigrationquestions.us. You post questions, we review them, and we answer them for you. Now, Brian, one of the questions we have is what date is the effective date of the birthright citizenship restriction if the court prevails? And the answer to that is that the court said it's going to be 30 days from any ruling. So playing out the timeline, July is what the court is going to be ruling in.
The government said they're going to go through their implementation once they get a.
Well, they were enjoined from going through the implementation. So the court, not only did they enjoin them from the birthright, the concept, but also enjoined them from going through an implementation stage, which they think it's 30 days.
So they need 30 days to actually prepare for it, okay.
And some people say 30 days is impossible. Yeah. Okay, so now, that's the timeline. So July, 30 days later. The next question we have is, is this case has implication beyond citizenship?
So the court case was basically about, can we do a nationwide order preventing the executive from doing something that maybe down the line we're going to determine is illegal? Can a single lower court do that? And this seems like it has the potential to be a major impact on all sorts of executive actions here. I mean, immigration is the current executive's pet project, and anytime they want to gravely, grossly, majorly change what their interpretation of the law is, they will have to, they will be able to do it, and then we'll be in that scenario where, okay, well, there's no court that can give that nationwide injunction. Maybe you get a patchwork of results, and maybe, after a year, once it gets to the Supreme Court, it'll be undone. But in the meantime, if there's damage done, and that depends upon how you interpret damage first, lots of people like these policies of this executive administration. That's that.
So here's the one question we have. If various states have various rulings on birthright, how is it going to work?
I'll let you handle that one while I type in this password here, Sam. Yeah.
So that is the number one objection that the Attorney General from New Jersey, that was arguing on behalf of the people, the birthright, against the government, was saying that how can we administer benefits? A child moves in from one state to our state, born in the United States, he's from, let's say, a state that did not rule in favor of the birthright citizenship, and then we have now to create them. Social Security number. Social Security numbers are not issued to those who are not citizen, and therefore we have to issue a Social Security number. Now, what happened to that Social Security number when that child moved to a state that does not enforce the ban on birthright citizenship? So nobody knows how that can possibly work, and the Supreme Court has the responsibility, in my opinion, but they may not think so, to come out with a ruling that makes sense, that resolve this issue. The next question, folks, I have here, does the place of birth, or is it the place you're living, would affect the child's citizenship if there's different rulings from the court? That's an excellent question and unknown, because we do not know how the court is going to rule on that. I mean, I think it doesn't matter where you're born. If you are in New Jersey, which I believe is one of the states that ruled in favor of the nationwide. I'm assuming probably California. I'm assuming perhaps. So for them, it doesn't matter where you're born as long as you're born in the U.S. Yeah. So if you're born in Texas, and assuming Texas does not favor birthright citizenship for a son or a daughter of undocumented or an immigrant visa holder, would not impact. So it's really the place, I believe, is going to end up where you live, not the place where you are born. Here's another one we have. You can stop me because I have.
Yeah, I'm going to take one from that was submitted. We have some printed off, some are online here. So here's a great question, employment-based question. I have a stamped and valid H-1B visa, valid up until August 2026.
Slow down, Brian. That's what people are telling you. Slow it down.
All right. I have a stamped and valid H-1B visa, valid up to August 2026. I want to travel to attend a wedding in the family in December 2025. Do you foresee any problems coming back? That's a long time away, I guess, is the bottom line. The average person with, no criminal history and who's, I don't think the average person has much to worry about travel right now. What I'm telling people, though, is what's very clear to me is these things can kind of change overnight. And I think those decisions, I wouldn't make a decision about traveling in December 2025 in May of 2025.
But I have cheap tickets. I'd like to buy them. They're on sale.
Make sure they're refundable.
But then these are 3 times as expensive. I mean, this is people don't have money. Pitless. I mean, it's a.
What's your solution to that problem, counselor?
Well, I'm highlighting the inequity of that. I don't have a solution. I'm just pointing the problem. You're the attorney here. I'm making you the lawyer. Solve that. It's going to cost me twice as much.
That is, friend, client.
So
things are changing on the ground rapidly.
Here's a little bit different way I would answer that question, Brian. I would say you don't have criminal record. You have a solid job. You're a law-abiding person. You're doing everything the right way.
That's what I said.
Okay?
Yeah.
Book the damn ticket.
Sure.
Book it, get your discount, and line up your trip, and be vigilant. Check the news until the day you leave. And
That's
don't
what
worry
I
about
said.
it. No, you wanted a refundable ticket.
Well,
Charge them 3 times as much.
Okay.
It's a lot of money.
You get the money. You get the money back though. You're going to feel good about that scenario. Yeah. Okay. Another one here, which is a real kind of fun employment-based issue. Noir on wage levels is an H-1B related one, it seems.
So notice of intent to revoke regarding a wage.
Yeah, on an H-1B.
On an H-1B case.
So after USCIS completed the site visit, and after 3 months, a noir was sent based upon the wage level in an H-1B LCA. USCIS says wage level 2 cannot be chosen. Instead, 4 should have been chosen. An RFE was raised. My employer was asked to submit the paperwork with an explanation. Is this a pretty common RFE or a serious issue? Please let me know. Thanks. So this... Go ahead.
No, is it a common or serious? Or it could be serious and common. These are not inconsistent.
Yeah. I would say it is an increasingly common RFE. I saw this one for the first time maybe around August of last year would be my guess. And is it a serious one? And the answer is potentially. I will tell a little bit more about these RFEs as I've read something similar. Basically, on your LCA, there's a wage level. You know, if you're a software developer, there's 4 levels of software developer, you know, based upon your geographic location and that job code, right? And the wages get higher, the higher the wage levels goes, right? And employers, for the purposes of filing an LCA, 99.9% of them, and you're allowed to do this under the rules, basically make a gut decision as to what wage level you should be based upon some guidance from the Department of Labor, right? And what USCIS is saying, they're choosing to interpret this Department of Labor policy in a very specific way. They're looking, as I understand it, at the educational and experience requirements for your job, usually from somebody like an end client if you're an IT consultant, and basically saying, no, see, based upon those requirements, you know, you should be at level 4 instead of level 2. And it's a complex RFE. I have fought these RFEs and won on them before. Actually, noirs I've won on, but you have a challenge there. It's basically
you need a sharp lawyer with a sharp pencil.
Yeah.
To get this done, and it's factually driven. So you're going to start with a fact. What are the facts? Yeah. And what have you said? And how can we reconcile between what you said, what the documents say, and how can we reach a conclusion in your favor and be truthful at the same time? That requires a skill. This is not a normal RFE for a normal response off the cuff by somebody who's doing a quick and not very thoughtful.
Yeah, I mean, anytime I have seen one of these noirs, I have found them to be poorly drafted by the government and basically challengeable, basically saying, you know, yeah, somebody told us that your job requires 10 years of experience, and the answer is, who? How do they know that? What authority do they have? And I have found that you can really challenge the government. You know, if you challenge their line of thinking, I mean,
the foundation of their evidence.
Yeah, there's definitely some work that can be done on that front for sure.
All right, so let's take questions on the air here. Brian.
Yeah, let's see what we got here.
So you can put it on the left here.
Oh, certainly, for the benefit of us both being able to see it. And there we go. From MK, my kid received 485 pending EAD after turning 14 years and biometric reuse letter. Do we still need to register as per new guidelines?
The answer is yes, you do. Yeah. I need to turn this off because I need to cough. I'm sorry.
The short answer there. Yes, you do. I guess, you know, one thing I'm pretty sure it's literally in USCIS's policy. It says, if in doubt, you know, register. and that's
Yeah.
that's
And
that.
they'll tell you, and they will not register you. They'll tell you you're not required to register.
Yeah.
So that's a good thing.
Yeah. Let's see here. There's a question here. This is like breaking news from today, so I haven't had the opportunity to read too much about it. But SCOTUS lifted the ban on the Venezuelan TPS rescinding, and oral arguments sometime in the future. Will the EAD based on TPS be invalid?
So this is double negative, rescinding the ban.
Yeah.
Lifted the ban. Put this back. Let's put that back on the screen here so people understand it. Lifted the ban on the Venezuelan TPS rescinding.
Yeah.
So there was a ban. So there was a TPS for 400,000 Venezuelan. 400,000.
Biggest. I think we looked this up. What's biggest TPS population in the United States, right? Yeah.
And it was going to expire in 2 years, I believe. So it is not going to expire now. It's in 2 years, and the government rescinded it now. They issued, I think, in the Federal Register.
I think before the prior administration went out, they extended it, and then basically the new administration did a Control Z on that to undo it and put it back.
They went to court and they stopped the government from making 400,000 people overnight illegal. It appears, and I have not, because I've been busy with Brian.
Yeah, we've been talking for the last hour about this issue.
Looking at the Birthright Citizenship, I haven't not seen the news, and I'm being told here by Y. Hori that ban, that's going to have again, it depends on how much and what they said. Of course, the devil is in the details, so it's not news released because haven't read it, I'm just highlighting it. Yeah. But let's move on here and answer questions. We got a couple more Birthright questions here that we asked, but let's go to Runyon here.
Yeah. I had asked last week about MTR. My daughter has AP. Is there a way to check whether she can travel and AP is valid? So the answer is, I think what Runyon wants here is there a spot where I can look it up and see whether it's valid? And the answer is no, but here's what I will tell you. Typically, I don't touch wood. I don't see many I don't see many I45 decision notices, but in the I45 decision notice, the ones I have seen in the last couple years, they will usually tell you exactly when an EAD and AP become invalid, and they usually take a time frame to it.
Now, can you explain to Runyon if his daughter, who has a high school program here studying and have a very complete and engaged life in school and sports, neighbors and friends, leaves, and then on her return, they say, no, we get this adjustment denial. I know it didn't say.
We didn't deny it.
And then you get this moron at the airport that say, I'm not sure I'm comfortable letting you in on this advanced parole. It looks like your adjustment status is denied, and then they're pending appeal.
Yeah.
I can't let you in. How much work does it take to bring that girl back? Now, he does not have an H-1B. Mm-hmm. He's now an H-1B, so she's now an H-4.
Yep.
She's now
forced to the consular process when Runyon eventually gets that green card.
Or he has to get an H-1B filed. He has to leave. What does that do to his pending MTR?
It shouldn't abandon the.
Of course, it will abandon because it will abandon the adjustment.
You're probably
okay. Risk abandoning it. To me, Runyon, this is super risky maneuver.
I agree. My answer is don't use that AP.
Yeah, super risky maneuver.
Yeah.
Please. That's the only thing I can say. She has an advanced parole. She can go and come back, and nobody's going to ask any questions. But to me, I would want to read this decision. I
wouldn't use that. I wouldn't think anybody. I think people are going to ask questions as soon as they see that AP. Yeah. AP derives from the I-45. They always bring people who would use APs into secondary inspection anyway. To check the validity of these documents. And if the I-45 is denied, there's that.
So as we have 1 more minute left. I heard that some people will maybe rendered stateless if the executive order is effective. What countries?
I don't have a list of countries, and I don't want to comment on the law, the citizenship laws of a bunch of different countries around the world. But man, you're plucking my immigration lawyer heartstrings when you talk about stateless individuals.
Well, Justice Sotomayor said that.
Yeah.
In the hearing, she said during the hearing, she said it will render some children stateless if they cannot be citizens in the U.S. and there are certain laws in certain countries that will not make that child a citizen if they're born in a foreign country. We did a quick Google, and absolutely I don't stand behind these, okay? But potentially a child born abroad to one parent who's Indian and the other parent is a foreign national must register within 1 year, otherwise it's not automatic. So potentially.
Yeah,
and they say the Indian law is very complicated, so don't assume anything we're saying here is
it's a fundamental problem with it, though. Basically, if you're not giving them U.S. citizenship, are they going to have any citizenship at all?
Yeah.
And there's basically, that's just something you don't want to do to people. It causes real problems in the world when there are people out there on the planet with no country looking out for them, nobody out there to advocate for them beyond themselves. There are literally treaties against creating stateless individuals.
Again, I don't stand behind it, but Germany, if the parents are born after year 2000, abroad, not in Germany, their parent abroad, and the child is born abroad, that child is not automatically a citizen.
Yeah, and now it sounds like a really crazy, unlikely scenario, but you know what I call that? A court case, you know?
So then there's other countries. So yeah, that's a good question that we have. So it's not the final. Wait until July to see what's going to happen. I'm not going to predict anything, Brian.
I don't know. There are just...
It's a dilemma. It's a really difficult case.
Yeah, I guess here's what we know for the time being. The nationwide injunctions are still lawful.
Until July.
At this time. That's the takeaway.
And then we'll see what happens in July. All right, guys, thank you. We'll see you Monday at